copies to send to the Supreme Court, my writ of certiorari. And I got stopped. I had an expired license plate on the car, an expired inspection sticker, and no driver's license because I had deliberately gotten rid of the driver's license. Since then, I have gotten it back because I have to drive him back and forth, and my battle has already been fought. So no sense in having to put up with all that again. But I put up with it then. So I got stopped by this cop. And he wrote me a ticket for $560. And he said, here, sign this. And I said, well, I will not sign it except under duress.
Right.
He said, you can't sign it that way. And I said, well, then I will not sign it. And he said, well, then I'll have to take you to jail. And I said, well, go ahead. But I'm not going to sign that ticket except under duress.
Right.
And it went on for 15, 20 minutes, and the car started heating up, you know. And I said, can I turn my engine off? He said, yeah. So I turned it off and went on. And so finally he said, here, sign it. And I signed it under duress.
Right.
And then I went to court with it, to the Meadows Municipal Court.
Right.
I filed my brief, and I got it in here, traffic court. I'll read it to you in a minute. Got my brief, and I gave my brief to the prosecutor, who happened to be a 70-year-old legal scholar.
Oh, wow.
And I gave that to him. And he walked up, and he told, there was only 2 cases on the agenda that day. Mine was first, and then another one. And the prosecutor walked up to the judge and said, Your Honor, I have no evidence I can present against Mrs. Martin due to lack of jurisdiction. I am not 14th Amendment.
There you go.
I am de jure.
And he let it go.
And it was dismissed.
Perfect.
$560 worth. And you talked about mouths dropping open. I'll read this to you here. It says, since the Meadows Traffic Court is not a court of record, I had to deliver my brief of choice of counsel. Well, I'll pass up for that. That's why I had to presented it. And cases I cited, Hassel versus State of Texas, and several cases I cited here for my case. And the evidence against me, this was the ticket, you know, no expired driver's license, no driver's license, expired inspection sticker and all that. There was 3 different things there against me. I highlighted what was against me. And then the brief of the accused. Now this was my brief. Statement of subject matter and jurisdiction. To the Honorable Judge of said court, comes now Barbara Martin, a de jure citizen of the state of Texas, hereinafter known as the accused, and would respectfully show this honorable court the following. Let me get this better where I can read it better. Yeah. Get back where I was here. Okay. Comes in, okay, following. Requesting this court to please take judicial notice of the definitions cited from Black's Law and Webster's dictionaries, to wit, A, facts. On the 22nd day of October, 1997, the accused was traveling alone in her automobile, exercising her inalienable right to travel, when she was stopped by a City of Meadows police officer, J.H. Cox, who issued her a citation for an expired driver's license, an expired motor vehicle inspection sticker, and failure to maintain proof of financial responsibility. The accused was traveling in a safe manner on personal errands and was not in any way engaging in commerce or in any way opposing a threat to anyone else. The accused was detained by Officer Cox for approximately 15 minutes over the officer's protest, stating he could not accept a citation signed under duress. And after Officer Cox informed the accused he was being nice and he could take her to jail, the accused signed the citation signed under duress.
Right.
The accused was certainly under duress because Officer Cox stopped her with his patrol car lights flashing and approached her automobile wearing a badge and a gun, embarrassing her as if she were a common criminal while she was only exercising her inalienable right to travel. Her right to travel is secured under the Blessings of Liberty by the United States Constitution of 1787 and the Bill of Rights of 1791. According to the United States Court of Appeals for the Fifth Circuit, the claim and exercise of a constitutional right cannot thus be converted into a crime. Miller v. U.S. 230 F2D 486 at 489. In Hassel versus State of Texas, 149 CR, and I'll go to citation, and I dated 5/15/1986. This happened. No, I said 1946. Oh, that was back when the Supreme Court did. The state Supreme Court said information alleging that defendant operated a motor vehicle on a public highway without a driver's license charged no offense under Driver's License Act, since a driver's license is not known to the law because the act only authorizes issuances of operators, commercial operators, and chauffeur's license, and use of the term driver interchangeably with operator would not be authorized in view of the definition in the act of the term driver as meaning every person who drives or is in actual physical possession of a vehicle. And cited. The act only authorizes issuances of operators, commercial operators, and chauffeur's license for Commerce Code vehicles only. So doesn't it talk about me driving in my own car?
It's only in a commercial.
It's commercial.
It's
But see, they have put it all together, and this goes into all of that. I'll skip over all this stuff. And jurisdiction. The petition of this honor is regarding the above said violation as a citizen under the Constitution of 1787, the Bill of Rights ratified in 1791, and the precedent decision of Article 3 Justice Courts of Law. The accused is not a subject of the administrative and legislative Article 1 courts or bound by precedents of such courts deriving their jurisdiction from said authorities. Anyway, I'll go on down more on this. I want to read where I actually pass this here. See, I went to court with this. Get past all this. My computer seems to be slow to me.
That's okay. This is interesting.
You compiled this whole document?
Yeah. Of course, I had my good buddy Clifford Williams.
Clifford Helper
So
too.
he really knew constitutional law,
Ah.
and I studied constitutional law under him.
Mm.
In fact, he wanted me to go to college, and the American government, and America's history. I even bought the first books, and then I thought I can't afford to do that, man. As old as I am, so I quit.
And this was in the 90s?
Yeah, this is the '90s, I guess.
So it's about 20
Yeah,
years.
but I had kids to raise, you know. And let me get on down this other part here. This middle part's the good part. There's my dogs. They got to be heard, I guess. They think.
I like this. I was just reading through your United Daughters of a Confederacy. I've never seen something like that before.
Where are you seeing that? Oh yeah, I belong to that. I haven't gone in a long time. I am a member of the Daughters of the Confederacy. Okay, now I'm getting down here. So since the Meadows Traffic Court is not a court of record, I had to deliver my brief, choice of counsel, and petition for trial de novo personally to the prosecutor, who was 70 years old and a legal scholar. There were only 2 trials scheduled that day, mine being the first one, and the charges against me were in the amount of $560. The judge had just made the statement, these trials don't take long and will be out here in 1 hour. Just then the prosecutor walked in. He had just read my brief, my choice of counsel, and my petition for trial de novo. He walked up to the judge and told her, I have no evidence I can present against Mrs. Martin due to lack of jurisdiction. As a sovereign de jure citizen of the state of Texas, all of the statutory laws passed by the de facto governments do not apply to me unless I harm someone or their property. This is one of the ways that knowing and proving you are a de jure citizen of your state and learning that no statutory law applies to you unless you harm someone or their property really is important. You see, people don't know that. We've been dumbed down. Now, here's
First I've heard of this.
my motion for right of choice of counsel. Let's see, no, I don't read that. That's just where my right
Is
of
it
choice
fun?
I'm always looking for a new way to stick to the man.
Let me go down. I guess it's at the bottom of this page, my right to choice of counsel. I mean, I had a right to choice of counsel.
I've heard this before in John Wesley Rawls' books.
Mm-hmm. Now you get to meet somebody that actually did it.
Let me go down to this last one. I think it's what I'm looking for here.
So
It's
they
been a long time since I've even reviewed
read
this.
through it. And they weren't a court of record either, so they were administrative, correct? Not a court of record?
What, the Meadows?
Yeah.
I guess it's court of, I think it's court of record.
Well, at the first you said it wasn't a court of
Well,
record
maybe it
unless...
wasn't. Okay, maybe.
Right. I wonder if that made a difference as well. If they're not a court of record, there's nowhere to file.
So after you attained your recognition as a de jure
Yeah.
citizen, how officially did the government then treat you as a like an over?
Well, they don't mess with me, period. They sent Gerald a deal saying he owed a certain amount of money in taxes,
Mm-hmm.
and I had already informed them that I am not subject to their jurisdiction. And you know, they never did send me any. I didn't have to pay anything.
Is it not going to bother wasting the postage?
So he
money if you're not
didn't
gonna pay
fight that battle. I did.
Yeah.
So,
Hmm.
you just have to stand up and fight. You know, you have to study and learn what you're doing and know what you're doing and know what you're saying and fight the battle.
And tell them no.
And here's the affidavit.
So did you go in by yourself with these deals, or did you have a group of people with you, or
For what? On this court?
any of the courts?
No, it's by myself.
By
Let's see. I think Gerald probably went with me to the court, but he just went with me.
Right.
You know, but I handled it myself. Yeah. And said, affidavit. My name is Barbara Ann Martin. This is to the Honorable Judge of said court. I am over 18 years of age, and my place of abode is 23rd Judicial District, 12906 West Belfort, Houston, Fort Bend County, Texas, USA. I have never been convicted of a crime, and I am fully competent to make this affidavit. I have personal knowledge of the facts stated herein. I fully understand that I have a right to my choice of counsel in accordance with the Constitution. Therefore, I am hereby evoking that right, and I hereby choose Clifford William, J.D., as my counsel. So he was there, I forgot that. Because I know he is well qualified. I am aware of his educational background and experience, and I fully understand that he is not a member of the State Bar of Texas. See, they're all in compliance with them. I absolutely refuse to have any attorney who is a member of the State Bar because, 1, I know the Texas State Bar is unconstitutional. 2, I know the Texas State Bar is not an agency of the government. 3, I know the Texas State Bar is a corporation. 4, I know the Texas State Bar is not a public corporation. Now,
Kind of like
5,
the US Treasury.
I know that a vast majority of the public cannot afford to hire attorneys who are members of the Texas State Bar. Further, affiant saith not, and I signed it. Let me see what else is down here. I whited out all the signatures of my,
Right.
keep their names out of everything. Except Cliff's, because he's dead.
No longer requires protection.
Exactly.
Well, he wouldn't care anyway. Petition for trial de novo.
Way beyond
From
their
what I
reach.
hear, he wouldn't.
Huh?
From what I hear about him, he wouldn't care.
No.
Go for it.
He's the one that helps me with it. To the Honorable Judge of said court, comes now Barbara Ann Martin, a de jure citizen of the state of Texas, hereinafter known as the accused, and will show unto this honorable court the following to wit. I am not the statutory 14th Amendment person listed on citation number 103083. Because my status of citizenship is de jure, this court, Article 1 Tribunal, has no jurisdiction over me. Therefore, I am evoking my absolute right to a de novo trial to have this case adjudicated in a county court of record so I can properly prepare my defense. Thomas versus Whitman, 85, and I cite the case. The court must have had jurisdiction not only of the cause, but of the parties, and they didn't have jurisdiction over me. The Supreme Court of the United States held in Justices of Boston Munn Court versus Linden, and cites that case, that it is worthy of note that virtually nothing can happen to a defendant at a first-tier trial that he cannot avoid. He has an absolute right to obtain the de novo trial and he need not allege error at the first trial court to do so. Once the right to a trial de novo is exercised, the judgment of the bench trial is wiped out. My citizenship is my right of heritage, blood, and does not emanate in, around, under, or through the 14th Amendment. I am a member of the posterity of the We the People spoken of in the preamble to the Constitution for the United States, 1787, and the preamble to the Constitution for the State of Texas of 1845. These were the same one people, the original de jure citizens, who wrote the Declaration of Independence to secure their unalienable rights and ordain and establish the Constitution for the United States of America of 1787 to secure the blessings of liberty to themselves and their posterity. Your Article 1 tribunal is a creation of the Texas State Legislature, and your police officer gets their license from the same legislature. Therefore, both your Article 1 tribunal and your police officers owe their allegiance to that legislature and not the people who ordain and establish the Constitution for these United States of America and the Constitution for the state of Texas. Maximum law dictates that you cannot be greater than that which created you, thereby owing your allegiance to your creator, the legislature. The people written of in the preamble to the Constitution with the rights therein and more do not feel that justice is in the Article 1 court. The people have a separation of powers doctrine where Congress writes the law, the executive branch enforces the law, and the judicial branch adjudicates the law to determine if the law is constitutional or not. The Article 1 tribunal has no provision for this. The Article 1 court was created to uphold the statutory laws of the state, whereby that state's legislature is the de jure is legislature. The de jure citizen, a one of a kind of a people, heritage, blood from Europe, written of in the preamble to the Constitution, are not statutory creations, and therefore the statutory court has no jurisdiction over the citizens. The office of the Attorney General, State of Texas, option number JM 266, quote, we conclude that the office of the district attorney is not within the judiciary exception. The office is not a court, nor it is directly controlled or supervised by the court. Its functions, moreover, are primarily executive in the same sense that its primary duty is to enforce the law. The district attorney, of course, is a law enforcement agency within the meaning of Section 3A8. Anyway, it kind of goes on down on that. So,
Genius.
I guess you want to hear all the rest of that. You can read it.
I'm going to read it.
So how can we claim to be de jure without going through what you did?
Well, you go through all of the same
Well, you gotta
research
prove
on
it,
where
you gotta
your
prove it up.
ancestors came
You gotta do what you
Do
did.
your genealogy
Uh huh.
and go back to your ancestry. And you prove that you can prove your de jure, you know, because
Prove that your family
you're
is from
descended from European stock.
a European stock, but also that you came here prior to the Constitution. 'Cause
No,
if
I wouldn't
you
do prior to
could,
the
you could,
Constitution.
you could immigrate.
You
could
can come over here
immigrate
yesterday.
After. You
Yes,
could
sir.
immigrate after and still be.
Yeah, yeah. You come over here and gain your citizenship.
Because you are of
Apply
the people
for-
that made the
Apply for your
Constitution.
citizenship, you know, make sure you have your citizenship here,
Mm-hmm.
you know, because you got the blood, your ancestry, you know, is your blood.
Yeah.
And see,
But-
they've dumbed us all down, say.
Yeah.
Like we're all 14th Amendment, and we're not 14th Amendment. And the reason they do that is because they want total control over us.
Mm.
But we are supposed to have total control over them.
Yes.
And if we can just wake up our people, you know, and get control of our country.
If you guys learned about the 14th Amendment and how much it controls you, we wouldn't be fighting the fights we're fighting right now, because
Right.
you would be just like Miss Martin, and you could go in there and say, see that?
I can carry that
Yep.
because none of your laws really apply to me.
Exactly.
Unless I-
Yeah, the only time your
Yeah,
law
but-
applies to me is if I harm someone or I
Well,
harm their property. I do not do that because I am a Christian, and God forbids me to do that.
To do what?
To harm.
To harm
harm someone.
anyone or harm their property. You know, a Christian can't do that.
Right.
Because you're going to face God when you do. You know, because I don't have the right to harm anyone or to harm their property.
Problem is what you're talking about is that the government agents would be ignorant of our rights because they're not familiar with de jure
So you'd have
citizens.
to go through the.
And they would
if it's going to be
violate
an
your
arrest,
rights.
It's going to be an arrest because they choose it, and you
The
have to
thing,
fight it
the
out.
thing
But
to do,
here's-
if we could do it, the thing to do, like I said, I'm getting kind of old. I kind of spearheaded it, I guess. But I'm old, you know, I'm 77 years old, and I got a real sick husband here.
Mm.
But the younger generation, you know, if you can start educating the younger generation to what their heritage is, they are not 14th Amendment citizens, subjects really.
Mm-hmm.
14th Amendment, not even citizens, they're just subjects,
Sheep.
you know.
Cattle.
And so that's the thing, that's the key to it, is to try to educate.
Because not only did they take the black race, which was enslaved, or the slaves, because it was more than just a black race. There were the Irish, there were several other groups of people that were enslaved. But not only did they take the enslaved people under the 14th Amendment, but they enslaved everyone that would accept the citizenship of the de facto.
Many people
Yeah,
coming over.
yeah, because they don't know any
Yeah.
don't know any better. See,
They were just happy to be citizens.
they've
And being
controlled
told
our
they were
school
citizens.
districts, our schools.
Now do you
We have
see
been
why?
dumbed down over the years. You know.
Now do you see why some people have power when they walk in a room, and they cower, and others don't?
Mm.
Because she taught me well. You don't know
Maybe,
that.
I don't know.
You don't know that.
They might kill me, but I'll just wake up in heaven.
Exactly.
You know, that's the way I look at it. You know, I've lived a good life. God's been good to me, and He's my ruler, not the government. You know. And the next one is why Barbara's case was. Here it is. Royce wrote this. Why Barbara's case was dismissed for failure to state a claim. He said the reasonable person might have the question, if Mrs. Martin's case was valid, as it appears Lynn Hughes thought it might be, and he did, then why did her case get dismissed? After discussion of the situation prior to dismissal, reading the original complaint and the transcript, it became pretty clear why the case was dismissed for failure to state a claim. I hope to make the reader understand so that if they wish to retrace their roots to we the people who created this country, that they may do so without making the same mistake. So don't make the same mistake I did. I am subject to mistakes like everybody else. Let me start by saying that stating a claim in a request for declaratory judgment is a tricky matter. In Mrs. Martin's case, she took the high road, believing she could get both the federal and state of Texas governments to see truth and just leave her alone. Unfortunately, getting government to leave one alone does not constitute the stating of a claim for which relief can be granted. You can never cut the other side any slack because their attorneys know how to take advantage of you. The Federal Rules of Civil Procedure, Rule 12B, state as follows. Federal Rules of Civil Procedure, Title 3, Pleadings and Motions, Rule 12, Defenses and Objections, when and how presented, motion for judgment on the pleadings, consolidating motions, waiving defenses, pretrial hearing, how to present defenses. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required. But a party may assert the following defense by motion. And I put 6, failure to state a claim upon which relief can be granted. This rule merely states that if a plaintiff files a case asking something from the court which the court can't grant or doesn't ask for anything, then the court must dismiss the case upon motion for the defendant under this rule. Looking into Chapter 4 of this book on page 112, you will find Mrs. Martin's request for the court as the following. That the court issue a declaratory judgment declaring petitioner's legal status with respect to the respondents herein and with respect to the controversy described herein. However, when you read Mrs. Martin's complaint, there is no controversy presented to the court for adjudication. When one requests declaratory judgment, there must be some evil to be occurred. What is an evil?
Right.
Got something they'll accept.
It just has to be worded a certain way.
Yeah. Anyway, in this case, Martin wanted a declaratory judgment stating she was a member of the posterity spoken of in the preamble to the Constitution for the United States of America. But to what effect? Judge Hughes wanted an answer to what Mrs. Martin wanted him to do to the defendants, and there was no answer in the complaint. Well, I should have pleaded for money damages, and I didn't, because I was taking the high road.
So it's
Even if
basically
it was
saying
just-
that we had to.
Yeah.
Even if it was just to cover your court costs.
Yeah.
You have to ask for something.
Yeah. When stating a claim to which relief can be granted, one must specifically ask the court to do something to the defendant. For example, in a breach of contract claim, the plaintiff must ask the court to order the defendant to pay him damages or to order what is known as specific performance, that the defendant be ordered to do what he or she agreed to do in the original contract. In tort case where the defendant injured the plaintiff in some way, let's say a battery, the plaintiff might ask the court to order the defendant to pay hospital and legal bills as a claim for which relief can be granted. In Mrs. Martin's case, what she really wanted was more than to be left alone. She wanted her name to be removed from the IRS records as a person required to file and pay taxes. For defendant Texas, Mrs. Martin wanted basically the same thing, that she was not required to submit her family automobile to inspection and registration, as well as to not be required to submit to the licensure scheme required of persons known as drivers. Say that's how they make money. It is important to note that judges are not supposed to help either side of a case. From the way Judge Hughes approached Mrs. Martin by asking what she wanted. See, I was in federal court, Judge Hughes. That's downtown Houston.
Yeah.
Since it wasn't what she wanted, since it wasn't in the complaint, I feel as if he actually went a little out of his way to try to help her to see what he needed from her. Had Mrs. Martin been able to articulate a claim for which he could have granted relief, Mrs. Martin may well have won that day. Beyond that, all the conclusions of the case, Judge Hughes has admonished Mrs. Martin that if she brought that case again, then she would be sanctioned. And that much would be true of anyone bringing a case that had already been settled. What he could not tell Mrs. Martin was that she could amend the case, state a claim for which relief could be granted, and then go back into court for that relief.
So they left the door open for
Yeah,
you.
they left it open for me, and but I
without
just never
telling
did
her.
do it. Yeah. However, Mrs. Martin did, but see, I'm doing basically this because I wasn't seeking money or anything for myself, but I want to get the truth out. You know,
Right.
like with y'all, and get the truth out and get with the people. That's what I want to do. That's all I want to do. However, Mrs. Martin did get part of the relief she wanted because the IRS removed her from their records as a person required to file and pay income taxes, and they did remove me.
So,
And I owned half of the pest control. See, we owned a thriving business here for 39 years.
So did they take the pest control off as well? Or just...
Just me. I owned half of it,
So you paid...
so I didn't pay nothing. Gerald paid. I didn't pay.
Oh
He didn't
man.
fight the battle. Anyway, however, Mrs. Martin did get part of the relief she wanted because the IRS removed their records. As okay. What about Mrs. Martin getting clear of state entanglements related to person? While there is nothing tangible to which we can point, as we can the actions of the IRS, we can point to the application of the concept to Mrs. Martin's traffic case in the municipal court, City of the Meadows, which was dismissed without me paying a dime. As we all know, local jurisdictions are loath to give up their control of their income stream, realized as the outcome of traffic law enforcement. For many cities and counties, traffic fines amount to a large portion of their annual budgets, which should not be, but that is a different rant. So they
Absolutely.
bleed you for everything they can. Because most jurisdictions budget based upon their traffic enforcement income, it is hard to get a judge in these jurisdictions to dismiss cases unless they believe that enforcement will cost more than they receive in fines. But in Mrs. Martin's Meadows traffic case, there was a different result. As a reader sees in the description of the documents filed and disposition of the case, the attorney for the state stated to the judge that he had no evidence to bring against Mrs. Martin due to lack of jurisdiction in the case. So, see, I didn't have to pay anything in Meadows Traffic Court. The potential fine in that case was $560. Cities don't like to give up that huge amount of money, but in that case, the state attorney admitted for the record that there was no jurisdiction because I am a de jure citizen.
You're out of it, yeah.
And I did not harm anyone or harm their property. So, okay, okay, why would the court have no jurisdiction of the cause of action? The simple answer is that it would have jurisdiction over traffic tickets. Where jurisdiction was lacking was over the person in this case, the de jure citizen before the court known as Barbara Ann Martin. In conclusion, Mrs. Martin's case at the federal level was lost simply because she failed to state a claim for which the court could grant her relief. If it was a mistake that could have been corrected and probably would have, had Mrs. Martin understood Judge Lynn Hughes' admonition not to bring the case again. The important thing for the reader, of course you learn through all this stuff, the important thing for the readers to